Good morning, good afternoon, and good evening to each and every one of you, wherever you are tuning in from. I'm Karen Abraham, and I'm the co-chair of the Traditional Cultural Expression Subcommittee. And welcome to AIPPI's webinar on traditional knowledge and cultural expressions, appreciation or appropriation. I am told that we have registrants from over 40 countries spanning the globe, from Australasia to Latin America. So welcome everyone, welcome to the session. I would like to go through some housekeeping announcements before we start. If anyone wishes to pose a question to the panelists, please do so and submit your question in the Q&A box. We will take all the questions at the end of the session. If you do face any technical issues and problems, whether it's audio or visual, please send a message to the chat box and our admin will help you out there. I would now like to invite Mr. Ralph Knack, the Deputy Reporter General of AIPPI's Bureau, to give us his welcome remarks. Ralph.
Thank you very much, Karen. Warm welcome from the side of the Bureau of AIPPI. We are extremely pleased how the series of webinars progressed. And I'm also very sad because I learned that this is the last one from this very interesting series, which I very much enjoyed. So I very much encourage the committee to continue their work after the upcoming AIPPI online Congress, which you should definitely attend. If you haven't registered yet, do so now. So this series was meant to give you or to enhance your knowledge about the foundations of this topic. And maybe in the future, AIPPI and this distinguished committee will work on special and more targeted issues related to this topic now that we got all familiar with the foundations of that law. You have already seen Karen Abraham, who will be the moderator for today's webinar. I thought actually it's not necessary to introduce Karen to you because she is one of the most well-known figures in the intellectual property world globally, and in particular Asia. But of course, maybe there are some of you who have not yet met Karen. So Karen is the head of the intellectual property department of Schern Delmont. She covers all areas of intellectual property and has more than 30 years of litigation experience in intellectual property matters, appearing in the Apex Court of Malaysia. Next to her litigation practice, Karen is also a very distinguished and very well-known IP commercial and transactional advisor, regularly advising on huge licensing and IP transactional deals. Karen is currently the co-chair of the Traditional Knowledge and Cultural Expression Subcommittee. And in that role, she will kindly guide us through today's webinar. And we are very pleased to have you, Karen, here as the host. Over to you, Karen.
Thank you very much, Ralph, for that very kind introduction. So let's get started. Let me first start off by introducing my esteemed panel of speakers. First, we will have from Paris, France, Lily Martinet, who is currently the officer in charge of Intangible Cultural Heritage at the Maison des Cultures du Monde. And she teaches a course on the International Cultural Heritage Law at the University of Sorbonne. Now, before Lily started joining Max Planck Institute in Luxembourg, she was a postdoctoral research fellow at the Institut des Sciences Sociales et Politiques. And as a postdoctoral researcher, she was responsible for coordinating the OSMOS program. And this program is a comparative study of national experiences in relation to intangible cultural heritage law. Lily has also worked on the implementation of the 2003 Convention for the Safeguarding of Intangible Cultural Heritage. And she did this for the French Ministry of Culture and for the French National Commission for UNESCO. Her PhD dissertation on traditional cultural expressions in international law was selected in 2019 for publication by IRJS Editions. Welcome, Lily. Next, we have from New York, Lydia. Now, Lydia Gobena is a partner in the international group of the intellectual property law firm Frost, Zelnick, Lemon, Zissou in New York. Lydia counsels and advises clients on international trademark, industrial design, copyright, and unfair competition issues. She develops strategies for acquiring, enforcing, and assigning intellectual property rights with an emphasis on foreign laws and international treaties. She litigates international and multi-country conflicts and advises clients on IP transactional issues in the context of IP portfolio audits and due diligence for acquisitions and divestitures. Lydia has championed countless court and trademark office decisions for major brand owners, acknowledged their fame in their trademarks in jurisdictions around the world. And she has secured one of the first criminal convictions for trademark infringement in Chile. So welcome, Lydia. Then from Panama, we have Audrey Williams, who is the founding partner of leading IP law firm Studio Benedetti, where she heads the anti-piracy litigation department. Audrey graduated in law and political science from the Universidad Santa Maria la Antigua, Panama, and obtained an LLM from Bolt Hall School of Law, University of California at Berkeley. She has practiced IP law for 30 years, including trademark prosecution and litigation, as well as copyright litigation. And she is currently the vice president of the Panamanian Association of Intellectual Property Law. So welcome, Audrey, and thank you for joining us. And finally, from New Zealand, we have Linnell Tufari Huria. Linnell is an intellectual property expert who has assisted clients in all aspects of trademark protection, management, and enforcement. And she was the first Maori patent attorney in New Zealand. She has acted for a diverse range of clients around the globe, including sole traders, startups, Wanau, Hapu, and iwi organizations in New Zealand, to multinational companies across North America, South America, and Asia. Linnell is regarded as one of New Zealand's leading experts on indigenous intellectual property law in New Zealand and in the Pacific. She specializes in advising Maori organizations on IP issues and is passionate about helping Maori navigate the IP system. In her experience, IP is seen as expansive and not in alignment with the Maori worldview. She's committed to bridging the two worlds. Linnell is currently the chair of the Indigenous Rights Committee for the International Trademark Association. Welcome, Linnell. So this is the overview of today's program. We're going to start back to the drawing board with the historical landscape that we find ourselves in, where these elements of traditional cultural expression were first recognized as a right. And then we're going to go through tackling the question of appropriation and the question of exploitation of those rights. Having done that, we're going to have a look at the possible legal frameworks, how we protect those rights once we've identified them. And finally, how we engage with the stakeholders and the right holders in the whole spectrum of the subject that we're talking about today. So what is traditional knowledge and what is traditional cultural expression? Now, there is no universal definition of traditional knowledge, or TK. But according to the World Intellectual Property Organization's definition, TK is knowledge, know-how, skill, and practice that are developed, sustained, and passed on from generation to generation within a community, often forming part of its cultural or spiritual identity. Now, TK can be found in a wide variety of contexts, including agricultural, scientific, technical, ecological, medicinal knowledge, as well as biodiversity-related knowledge. Now, traditional cultural expression, on the other hand, is also called expressions of folklore. And this may be considered as the form in which traditional cultures is expressed, forming part of the identity and heritage of the tradition of indigenous communities. This could include music, dance, art, design, names, signs and symbols, performances, ceremonies, architectural forms, handicrafts, and narratives. TCE are integral to the cultural and social identities of indigenous and local communities, as it embodies the know-how and the skills and the transmission of those core values and belief. And essentially, TCE's protection is related to the promotion of creativity enhanced in the cultural diversity and the preservation of culture. Those are the definitions of what we'll be dealing with today. Now, unlike centuries past when drawings on cultures for fashion or festivals or food was more commonplace and less contested, today fashion houses, brands, designers, and artists have been heavily criticized and chastised upon when they stray into territories of cultural inspired creations seen as appropriation. According to those who speak out against the issue, too many have drawn from other cultures for their own profit and gain without giving little or nothing back to the communities. Now, there are two main ingredients as to how cultural appropriation has become a hot topic in society today: the arguments of dominancy and trial by social media. I had a look to see what the definition of cultural appropriation was, and it was only a phrase entered in the Oxford Dictionary in 2017. And the definition says that it is the unacknowledged or inappropriate adoption of customs, practices, and ideas of one people or society by members of another, and typically more dominant people of society. So that is the Oxford Dictionary definition. So let us get started with our panel of speakers. Lily, it's imperative to really understand the historical landscape and the background of TCE and where we are now. And I can't think of anyone better than you, with all the research that you've done and your thesis and your dissertation. You have made such huge contributions to this field. So can you please walk us through it, Lily?
Thank you, Karen. So I'm going to take the opportunity of sharing my slides, first of all, to thank the organizers for inviting me today. It's a pleasure to be here and to talk about traditional cultural expressions. So I wrote my PhD thesis on this topic. And after spending years studying it, it still fills me with passion and joy. And my contribution is designed as an introduction to this topic. So it will at first focus on a historical presentation of the protection of traditional cultural expressions in international law. After this historical overview, I will etch out the key characters that define traditional cultural expressions. Then I will briefly explain why legal protection is sought for traditional cultural expressions. And finally, I will very briefly touch upon the relationship between traditional cultural expressions and intangible cultural heritage. So we're going to start with a historical panorama of the protection of traditional cultural expressions. So as you can see on this graph, the issue of protecting traditional cultural expressions is far from being new. It's actually quite ancient. It emerged during decolonization. What happened is that new independent states no longer had copyright laws in force, and the Western world was pushing for these states to enact copyright legislation and to join the Berne Convention. And in this push towards universal copyright protection, an issue popped up. And this issue was known at the time as the protection of folklore. The newly independent states pointed out that enacting copyright laws would protect imported artistic works from the West, but that works linked to traditional culture or folklore from the South would not be considered as elements protectable by copyright and would thus be in the public domain, free to be used by anyone. So enacting copyright laws would create an asymmetrical relationship between the Western states and the rest of the world. One of the practices that was discussed in the beginning was foreigners going into villages, recording songs and music, and then editing records and claiming a copyright on the record and royalties each time the record would be played on the radio. So to resolve this issue, there were discussions, and these discussions led to the adoption of a provision which was added in the Berne Convention in 1967. And this provision was aiming to protect unpublished works of unknown authorship. Unfortunately, this provision still remains a dead letter, since no states, to the exception of India, applies it. Then the subject of the protection of folklore was left aside until 1973. In 1973, the government of Bolivia sent a letter to UNESCO's Director General. And the story that is told behind this letter is that Bolivia was offended by the worldwide success of the Simon Garfunkel cover of El Condor Pasa, a song which was heavily inspired by traditional Andean melodies. And Bolivia, reacting to the success of this song, submitted a proposal bringing to the forefront the question of the protection of folklore. Bolivia sought to recognize folklore as a form of intellectual property. So this letter initiated a work which was realized by UNESCO and WIPO jointly. They studied the question, and they notably assisted the drafting of the Tunis Model Law on Copyright for Developing Countries. And this model law proposed to protect works of folklore with a paying public domain. In 1978, the examination of the protection of folklore was broken down into two approaches. The first approach was an interdisciplinary approach, which was entrusted to UNESCO. And the second approach focused on copyright aspects, and this was handled jointly by UNESCO and WIPO. In 1982, UNESCO and WIPO adopted the model provisions for national laws on the protection of expressions of folklore against illicit exploitation and other prejudicial actions. These model provisions, alongside the Tunis model law, had significant impact on shaping domestic laws of several states, and you can find some laws that actually had the same provisions for protecting folklore than the ones stated out in the Tunis model law and the model provisions. After 1982, WIPO and UNESCO worked separately. And an important thing I need to underline is that in 1992, the Convention on Biological Diversity was adopted. And this instrument introduced two important concepts, which are genetic resources and traditional knowledge. Both of these concepts addressed, among others, the practice of biopiracy, which is actually quite similar to the appropriation of traditional cultural expressions. And in 1997, WIPO initiated a program that brought together genetic resources, traditional knowledge, and folklore. And this program led to the establishment in 2000 of the Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge, and Folklore. The mandate of this committee is to work on an agreement that will ensure the protection of the three elements, genetic resources, traditional knowledge, and traditional cultural expression. The work is still ongoing in this direction today. In parallel to WIPO's progress, UNESCO continued its work on an interdisciplinary approach to the safeguarding of folklore. And this approach led to the adoption of two different instruments. The first one was a recommendation in 1989 on the safeguarding of traditional culture and folklore, and a very important instrument for the work I do, which is the Convention for the Safeguarding of the Intangible Cultural Heritage. And this convention was adopted in 2003. So gradually, UNESCO and WIPO both dropped the term folklore because folklore is thought to carry a negative connotation. WIPO decided to use traditional cultural expressions, whereas UNESCO preferred to use intangible cultural heritage. So there's a sort of separation in the vocabulary, although the subject is the same. So to sum up very quickly, this historical panorama in 2 points. First, the question of the protection of traditional cultural expression is an old issue. Second, traditional cultural expressions intertwine aspects of intellectual property with cultural heritage. So now that you have a historical overview of the topic, you might be wondering how traditional cultural expressions are different from other works that could be protected by copyright. So as Karen said, there's no accepted definition in international law of traditional cultural expressions, but by studying the work done by WIPO and UNESCO, it's possible to put forward three key characters that define traditional cultural expressions. First, they possess a cultural content. Second, they are of collective essence. And third, they are traditional. So I'm going to go over these three different features. And I will start with the cultural content. So first of all, traditional cultural expressions are a subcategory of cultural expressions. They are the result of the creativity of individuals, groups, and societies, and they have a cultural content, which means that they express a cultural identity through a symbolic meaning, an artistic dimension, and cultural values. Because of their cultural content, traditional cultural expressions have been conceptually attached to copyright law. The second key character of traditional cultural expressions is their collective essence. So traditional cultural expressions are linked to a human group, a community, a minority, or an indigenous people. They do not belong to an individual. They belong to a group that identifies itself to them. They express in this way a collective cultural identity. And the third key characteristic of traditional cultural expressions is that they are traditional. What we mean by traditional is that they are transmitted from one generation to another inside a human group. They extend in the present an intellectual activity of the past. They are at the same time ancient and contemporary. Through the process of transmission, there is a strong bond that is formed between a community and its traditional cultural expressions. There is a strong feeling of belonging and affection between a community and its traditional cultural expressions. And these cultural expressions are part of their cultural heritage. Now that I have a bit defined traditional cultural expressions, we can study why this legal concept was elaborated. So the notion of traditional cultural expression has appeared in international law as a response to the commodification and appropriation of traditional cultural expressions. Because traditional cultural expressions are considered as elements of the public domain, anyone can use them. They don't have to seek the consent of the community at their origin. It is not even necessary to share with the community the benefits arising from their use. And even though the community has created and invested its resource to perpetuate traditional cultural expressions, most of the time, people using traditional cultural expressions will not even mention the name of the community that created and transmitted them. And this can be perceived by the community as unethical and unfair. Here on this slide, you have two examples of appropriation of a traditional Maori tattoo. So on the left, you have the example of an appropriation by a fashion designer, Jean-Paul Gaultier. It was an advertisement published in Vogue. And on the right, you have the cover of a French magazine, which used the same traditional cultural expression. In some cases of appropriation, the traditional cultural expression is distorted. It is used without taking into account the meaning or the cultural values that they express. So here you can see on the right, women's sportswear. And this legging was inspired by Samoan traditional tattoos. And on the left, you can see traditional tattoos. So the legging was commercialized by Nike in 2013. And this product deeply offended the Samoan community, as this kind of tattoo is reserved exclusively for men. So it caused an uproar, and Nike had to pull the legging. So there are a lot of similar examples in the literature on traditional cultural expressions. In other cases, the person or the corporation using the traditional cultural expression is granted an intellectual property right on the work incorporating it. So the traditional cultural expression is in the public domain, but the work incorporating it is protected. As an example, on this slide, you can see the tattoo, which is on Mike Tyson's face. So this tattoo was actually in a dispute. The tattoo artist that realized the tattoo on Mike Tyson's face sued Warner Brothers for copying the design, which you can see on the poster of the Hangover movie. And this design is inspired by a traditional Maori tattoo. So the tattoo artist claimed a copyright on the tattoo, and the case was settled out of court, but the copyright was never brought into question, so it was never challenged. So in theory, the tattoo artist, which is American, could also sue Maori tattoo artists that would do similar tattoos on their clients. So to sum up, the core issue is whether rights should be granted to communities so that they can control the use of traditional cultural expressions and protect their economic and moral interests. Which brings me to my last slide. And I want to conclude by talking briefly about the relationship with intangible cultural heritage. So intangible cultural heritage is broader than traditional cultural expressions and traditional knowledge, but it encompasses them both. So traditional cultural expressions are intangible cultural heritage, and traditional knowledge are intangible cultural heritage. So intangible cultural heritage is broader because it also includes foodways like beer culture in Belgium, or social practices such as traditional horse games. Because traditional cultural expressions are part of intangible cultural heritage, a delicate balance needs to be found between protecting them and preserving the dynamic nature of culture. This dynamic nature requires interculturality, artistic freedom, and freedom of expression. Granting rights on traditional cultural expression could stifle cultural exchanges and creativity. We have to keep in mind that many art movements were born through cultural exchanges. I'm only going to cite one example, which is French Impressionism, which was influenced by Japanese art. If French artists hadn't been in contact with Japanese art and hadn't used some of the themes of Japanese art, there would not be Impressionism as an art movement in France. So I want to thank you for your attention, and I give back the floor to Karen.
Thank you very much, Lily. That was really enlightening, and for us to have that backdrop, so that we can have this discussion today about where it came from, what the background is, and where we are today. So to continue this discussion and really getting into the debate, I would like to invite Lydia to share with us some real life challenges faced, particularly in the United States, where there have been many cases, brand owners and also to discuss the economic impact on a brand when the brand is not mindful of the potential consequences when selecting inspiration, however artistically it is rendered. So Lydia, can you help us understand a little bit more about this whole concept of, being inspired and illustrating something which could be deemed to be, an appreciation, but then it evolves into appropriation?
Thank you, Karen. Hello, everyone. I'm honored to be here. I'm going to start sharing my screen. So I'm here to talk about the fine line between cultural appreciation and cultural appropriation. So my part of the presentation will really be sort of touching upon legal issues, but really sort of looking at what the impact of this is and how to sort of avoid it. So, fashion, as Lily said, as Karen has said, fashion, music, and art are often inspired by other cultures. And such inspiration enhances our global perspective. It brings us together. But it's one thing to be inspired by one culture, and it's another thing to wholly incorporate a design without proper attribution and really to appropriate it in a different context. So here's some questions to ask when a company is looking to sort of incorporate different elements into either their brand or their designs, etc. The questions are, am I crediting the source? Where did you get it from? Am I perpetuating a stereotype? Am I seeking to benefit financially without giving back to the source wherever possible? Because sometimes that may not necessarily be possible. And also, is the adoption wholehearted, or am I only adopting an element? So these are the questions that we really think that people should be asking. So here's some examples of inspiration that may have gone too far. One example goes back to 1999. So Donna and Karen, she drew attention for sending a buyer to the Western Arctic to collect older traditional Inuit clothing for the inspiration for her 2000 fashion line. She didn't really tell people why she was there. The community, concerned largely about its own intellectual property right, sought assistance from the media and instituted a letter writing campaign to stop her. This was discussed in WIPO's paper prepared by the Pawcatuit Inuit Women's Association. And it worked because while some of the items purchased by the company were displayed at their New York boutique, the collection was ultimately canceled. Here's another case from the United States, which actually turned into a lawsuit, where Urban Outfitters back in 2012 was sued by the Navajo Nation, the largest Native American tribe in the United States. They were sued for millions of dollars in damages for selling clothing, jewelry, flasks, and other merchandise bearing the tribe's names and featuring tribal-inspired designs and prints. Examples of some of the items were Navajo hipster panties and Navajo print flasks. The lawsuit alleged trademark infringement in violation of the Indian Arts and Crafts Act, which prohibits the misrepresentation of arts and crafts as Indian art in the United States. Ultimately, the case was settled back in 2016, and the parties entered into a supply and license agreement relating to Native American jewelry. The third example I'm going to give is a company that often gets into multiple, or has been often criticized multiple times for their different fashion shows, which are, have been quite popular over the past. Victoria's Secret, in 2010, they included a Wild Things section where the female models wore animal print lingerie, were surrounded by men, and printed sarongs and wrap skirts. The models were all painted in black shapes and lines and meant to resemble indigenous tribes. In 2014, they had models dressing in feathers and bright colors and native inspired prints. And for those of you who may not be aware, those Indian headdresses, which are called war bonnets, have both spiritual and ceremonial importance. And, not anyone could just wear these feathered bonnets. So it's really important to understand that by putting that into fashion show, you sort of minimize the significance associated with that. In 2016, Victoria's Secret did a Chinese-inspired design, and the problem with that was that it was worn by models who weren't Chinese. They also featured a nomadic adventures line inspired again by Native American dress. So, they've had quite a bit of problems, but, it's not only fashion companies. You also see celebrities who are often accused of cultural appropriation. And Kim Kardashian a couple of times have worn these things that are called Bo Derek braids. Well, Bo Derek, for those of you who are too young to know who she was or is an actress, and she was famous for a scene where she had these braids that were all on her head and she had like little beads on the bottom. And, that was inspired by Black women's braids. And, when Kim Kardashian says, well, it's Bo Derek braids, it sort of like doesn't take, first of all, Black women have often been criticized for having natural hair like myself, because it's often considered to be unkept or unprofessional, and to sort of associate the braids or refer to them as Bo Derek braids when really they come from the African American community, or the African community sort of minimizes that. And she's gotten into hot trouble a couple of times. Her sister wore a burqa, and then posted a picture in Dubai saying Habibi love. Katy Perry, actually Karen showed another image, which I am not referencing here, from Katy Perry, where, she dressed up as a geisha for the American Music Awards in 2013. Again, she wore cornrows. Beyonce, wore traditional Indian clothing and henna for her Hymn for the Weekend song with Coldplay. It was in the music video. What was interesting about that is there was a bit of debate, because some people thought it was cultural appropriation, and some people thought, oh, it's great to see sort of a dark-skinned woman wearing a sari. And more recently, Michael B. Jordan launched a rum brand called Géovert, which is the name of a carnival celebrated in many Caribbean islands, but it was tied to 19th century slavery. So it's really important to understand where you're coming up with these names, and the fact that it may be cool or chic, or you really have to understand that it can offend the people from particular communities. But fashion companies, celebrities are not the only ones. In the US, there's been a movement to get sports teams with Native American related names, mascots, or logos to change their names. And this has actually met with some success. For years, there was a trademark dispute over the Washington Redskins name. The Native Americans, they sued the Redskins, and ultimately, I think what caused the Redskins to change their name in part was last year, everyone around the world saw what happened in the United States with respect to George Floyd and the protests. And so, the Redskins finally changed their name to the Washington Football Club. More recently, the Cleveland Indians, announced that they were also changing their names, and they just recently announced off the press that it's the Cleveland Guardians. And also chefs and restaurants owners will often make recipes that are inspired or taken from other cultures, but really not attribute them. So it's really important to understand where the source of these things come from. If there's a history which is painful, people have to understand that, and we as lawyers, I think we have to understand that. So on one hand, you have the legal issues of the trademark infringement, I think, but really understanding culture and understanding things, what not to do, make us better lawyers. So here's some best practices for avoiding cultural appropriation. There are a number of advocacy groups to support Native Americans and indigenous groups. Really, if your client wants you to help them clear sort of particular design or particular name, Google or some other search engine is your friend. And it's important to sort of do that. And with the Maasai warriors, who are known for their brightly colored blankets and their beaded work, Lightyear's IP founded the Maasai Intellectual Property Initiative, for example, to help them gain control of their brand. So they help them recapture trademarks relating to the tribal name, but also help them secure licenses with different brands in order to pay for initiatives relating to education, health, and securing waiver rights. So, I touched upon this before. How do you prevent appropriation? Because again, there could be appreciation, but really, how do you prevent appropriation? When you're talking to designers, quiz them about where they got their ideas to really sort of get to the bottom of things. You might want to engage outside counsel or internal counsel to really do quick assessments. And, at the minimum, you want to, if you're going to use a name or a trademark, conduct a trademark search. Also do some online searches for the proposed collection names, because often you'll find information, if it's out there, to show that may or may not be the best thing to adopt. Consider hiring designers and marketing professionals from different backgrounds, because they will enhance the diversity and also may help prevent potential issues. Because if you have a design group or you have internal personnel that aren't diverse, they may not understand that the particular designer name that you're going to pick may be offensive. Also, if your designers were inspired by a particular culture, see if there's a way to collaborate with the source of that inspiration. So, things to avoid as IP lawyers, the first thing we want to say is avoid wholeheartedly copying designs from anyone. That's a no-go. Obviously, and there have been cases, don't claim ownership of designs that clearly come from another source. When you style fashion shows, and if you're going to have like a Chinese inspired dress, or if you're going to have something inspired by African-American culture, don't have models that don't reflect that culture as part of, make sure you include models from those different cultures in your show. I mean, frankly, diversity on the runway is an important thing. And especially after George Floyd has become even more important. And understand the ethnic hairstyle, where it's the cornrows, or if it's the dreadlocks, or things like that. Just be careful to understand that these are things that come with certain affiliations or understandings, and that having natural hair or having an afro on someone who's not Black may be offensive. And certainly avoid using Native American or indigenous group names for style collections or trademarks. And then when you respond to objections, it's really important to be mindful about how you respond. You shouldn't ignore the objections. It's really important to respond in real time, and if appropriate, consider an apology. One of the things is, there was a prime example of like when, for example, Marc Jacobs got in trouble a few years back with his fashion show with these multicolored dreadlocks. His apology that sort of talked about Black women straightening their hair for years, or saying he doesn't see color or race, really met with a backlash, because he didn't really sort of stop and think about how he was going to respond. And to the extent that you can contribute to relevant organizations, I think that's important. Sometimes you may not, because if you have dreadlocks or curly hair, you may not have that. Also, if you've sort of offended a particular group, consider opportunities to collaborate, in the future with them. And, and some of these collaborations, I might add, have helped, particularly with indigenous groups, where money has gone to them and there have been licenses and they've been able to build schools and stuff like that. But collaboration is an important thing to consider. Maybe it may be helpful. And now I'll stop sharing my screen.
Thank you very much, Lydia. That was so helpful, and to sort of navigate us through those examples, and then some key takeaways and advice that we should have consider when advising clients and who are involved in these sort of creative in the creative industry. So thank you very much for that. Now we turn to Audrey from Panama. It's remarkable, Audrey, the legal infrastructure in place in Panama for the protection of TCEs. I know that Panama has its own sui generis legislation. Can you please share with us how this came about, and are other Latin American countries also following suit?
Thank you, Karen. Sorry. Let me. Okay. Oh, thank you again, Karen, and thank you, the organizers, for inviting me to participate in this seminar. So we are going to see possible forms of protection and current forms of protection of available for traditional cultural expressions. And we have traditional forms of IP rights that have been used to protect traditional cultural expressions, such as collective marks, designations of origin, copyright, but also the development of a special laws, special IP system. That's the sui generis approach. So I'm going to refer to how traditional cultural expressions are protected in certain Latin American countries. Starting with Mexico, we have the system of collective marks that has been used to protect certain traditional crafts, such as carved wood furniture, artisan weaving, and also the system of designations of origin, which has been used to protect certain traditional crafts. There are actually several designations of origin that have been achieved in Mexico to protect traditional cultural expressions. Here we have an example, the Talavera traditional pottery from Puebla, Mexico. Also, copyright law in Mexico, it was amended in 2020, and an important thing was with this amendment is that TCEs were rescued from public domain, because before the amendment, there was a section in the law that provided that in the cases of cultural expressions or traditional works where the author could not be identified, then those cultural expressions were part of the public domain and could be used freely by the public. So that was corrected with the amendment, and now all literary and artistic works and popular artwork from popular cultures and expressions of traditional cultures that represent the identity and culture of indigenous people are protected, and their ownership rights are recognized. So the copyright law in Mexico forbids commercial use of those traditional cultural expressions if they are not authorized in writing by the indigenous community. There's actually an initiative in Mexico also to move to the sui generis approach. And there's a proposed law for the safeguard of knowledge, cultural, and identity of indigenous and Afro-Mexican communities. It was presented to the Senate in 2018, but it has not yet been approved. But the proposed law intends to create a special IP system to recognize IP collective rights of indigenous and Afro-Mexican people in traditional knowledge and traditional cultural expressions that form their cultural patrimony. And the law provide, the proposed law would require that any commercial use by third parties would have to be authorized by the community in writing and through the execution of license agreements, and that would be subject to mandatory registration. Now, moving to Peru, we have also the system of collective marks in place, and it has been widely used to protect traditional cultural expressions. In fact, from time to time, the trademark office in Peru has eliminated the official fee that has to be paid for the registration of collective marks in order to promote more registrations from local producers and artisans. And a good thing is that in Just recently, in April this year, the Trademark Office decided to eliminate the official fee for good. So there's no official fee to be paid. Designations of origin have also been used in Peru, and also an amendment was passed to the industrial property law to include other forms of IP rights called traditional specialties, which include traditional recipes, traditional production and transformation methods. So Peru is another country that is adopting a special protection for TCEs. However, this amendment has not been passed. I mean, although it has been passed since September 2018, the regulations have not been drafted, so it has not yet been implemented. So seeing these traditional forms of IP rights protection, the problem I see with, for instance, with collective marks is that the parties receiving protection are only the ones, the members of the association that obtains the registration, but not all the members of the community are protected by that registration. And on the other hand, with copyright, we still see legislations where the folklore expressions and traditional cultural expressions are not protected because of the impossibility of identifying an author. And for instance, that's the case in Panama. In Panama, our copyright law expressly excludes from copyright protection traditional cultural expressions. And on the other hand, designations of origin also, we know it's a complex procedure to be able to get a designation of origin. It's costly also and requires a lot of formalities. So Panama has adopted a special IP system for the protection of IP collective rights of indigenous people. So a special law was enacted in 2000 and was regulated a year after. And with the law, there's recognition of IP rights in traditional knowledge of indigenous people, which includes their creations, inventions, symbols, design, and their cultural expressions that involve their history, music, art, and any artistic expression that is susceptible of commercial use. So in our law, every form of traditional knowledge and TCE derived from indigenous people, customs, traditions, beliefs, spirituality, religion, worldview, all that is part of their cultural patrimony and cannot be appropriated by third parties. So the law creates a special category of IP rights, which are called IP collective rights of indigenous people. And the law expressly protects traditional dresses, musical instruments, music, dances, work tools, traditional medicine, crafts, traditional techniques, any other traditional cultural expression is protected. The law creates a registration system. It's a special registry within the Patent and Trademark Office in charge of the Department of Collective Rights and Folklore Expressions. And before this entity, the indigenous community can file applications for the registration of their collective rights through their General Congress or Council. And the application must contain a description of the collective right and its history, techniques used. Also, rules of use must be submitted. And the good thing is that registrations have no expiration date and are free of charge. Actually, our Department of Collective Rights offer free legal advice to communities on advising them on how to protect their rights and also providing them with forms to draft their rules of use and also their license agreements. Here are examples of just few examples of registered rights. This is a Shakira. It's a nave boucle necklace technique. Here is the Mola Cuna Panama. which is probably the one with more international exposure. And it belongs to the Gunayala community, indigenous community, and it originated with the tradition of Gunayala women painting their bodies with geometrical designs. So these are examples of registrations that have been obtained. The law also provides for the need of authorizing any commercial use that third parties intend of collective rights of indigenous people. And it has to be done through the execution of license agreements. And the license agreement must include the uses that are being licensed, the term of the license, and the royalties. So it's not for free. There must be royalties paid to the indigenous community. And the licensee must comply with the rules of use, and the license agreement is registered with the Department of Collective Rights. The law also provides for penalties for any unauthorized manufacturing, assembly, distribution, or circulation of products that reproduces IP collective rights, and it can be pursued civilly or criminally. In 2007, our penal code was amended, and then these conducts were categorized as crimes, and they have a imprisonment term of 4 to 6 years if it's pursued criminally, either ex officio or by denunciation or criminal complaint from the community, the indigenous community. There are fines also of from $1,000 to $5,000, and 50% of the fine goes to the indigenous community. And of course, in any case, either civil or criminal, the unauthorized products are impounded and destroyed. Here we have examples of cultural appropriation cases we have had in Panama. The first one was a criminal complaint brought by the Gunayala indigenous community against a local liquor manufacturing company that was using mola designs to have them printed in the bottles of their liquor. And the Gunayala filed a complaint. The Intellectual Property District Attorney's Office granted an injunction against preventing the distribution of these bottles, and the case was settled out of court. The second example is also a criminal complaint brought by the Gunayala Congress against one of the largest local coffee producer in Panama. This company, Café Duran, they were selling mugs that were being advertised as having mola designs, openly advertised as using mola designs from Gunayala people. And well, they acted and an injunction was granted. The case was settled out of court. So far, we don't have any judicial decision, but the law has worked to prevent the unauthorized use of traditional cultural expressions. In the international arena, we had quite a famous case. It was Nike, which in 2019 announced the launching of a shoe, the Nike Air Force One Puerto Rico, because it was a tribute to Puerto Rico, but it actually had a mola design, a mola pattern design in the shoe. So again, the Gunayala Congress issued a public statement, sent a letter to Nike. There was also public requests. And as a result of that, Nike issued a public apology and canceled the launching of the product. The law has also allowed successful collaborations between third parties that want to use the TCEs and the communities, the indigenous communities, so they can receive proper compensation. Here, the example I have is actually the first license agreement that was signed in Panama in 2013, where the company acquired the right to use mola designs to have them printed in fabrics to produce like handkerchiefs, scarves, and it has been, for many years, the license agreement has been in place, and the company pays royalties to the Gunayala people. And it's, well, this particular brand and these products are being sold internationally. So the law has allowed this kind of collaboration that gives attribution to the community and also compensation. So with this, I conclude my part. Thank you. Thank you very much.
Thank you so much, Audrey. That was fascinating. We have so much to learn from Panama and your neighboring countries, and how advanced they are in terms of being proactive, not only just to have the legal framework, but to actually enforce it and have those fruitful results. So that's fantastic, and thank you for sharing that with us. Last but not least, Linnell from New Zealand, you yourself have Maori heritage, and I know that you've devoted a large part of your practice to safeguarding the intellectual property and cultural rights of the Maori community, making sure, ensuring best practices are adopted when we engage with them. So maybe you can share with us, how do we go about this, and what do we need to do?
Kia ora, Karen. There we go. Kia ora, Karen. Kia ora koutou. Tuatahi, he tika me mihi kia koutou te whānau o AIPPI, mo tō tono ki a hau ki te haere mai ki te kōrero ki a koutou katoa. Tuaroa me tika he mihi ki ngā kai kōrero, e tuana i roto i tēnei kōrero. Nō reira, ka nui te mihi ki a koutou katoa e whakarongo ana ki tēnei hōtaka. Ko waiau, he uri ahau no Taranaki, ko Taranaki te maunga, ko Tangohoi te awa, ko Aotea te waka, ko Ngāti Ruanui te iwi, ko Hāmua, ko Hā Pōtiki ngā hapū, ko Taiporua nui te pā, ko Linnell Tawhihuria tōku ingoa. Tēnā koutou, tēnā koutou, tēnā tātou katoa. Hello everyone, thank you Karen for the kind introduction, and thank you to AIPPI for the privilege to speak to you all today. Also, I just want to acknowledge my co-presenters, such amazing knowledge, all scrunched down into quite a short period. I'm sure we could delve a lot more, and I'd love to stay connected with all of you, because it would be good to stay connected on a professional basis at least. So thank you for your contribution. So I just shared with you my whakapapa, my heritage or my genealogy to where I come from, and I'll make references to that during my presentation today, just to help provide some context to what I'm going to discuss. So I'm going to just now share my screen, and I hope that's working. Good. There we go. So I'm going to talk about how engaging with Indigenous stakeholders, and a lot of the questions that I receive in this area is, first and foremost, a lot of people have issue, where do we go to? And then what is the process? Because it's not always entirely clear. And so whilst I am not going to provide you with these steps, what I am going to provide you is some tools to help guide you should you have to engage with Indigenous peoples. So I'm going to talk about 3 stages. So in the beginning, in the middle, and at the end, because I think it's important to understand that this is a partnership. And so it does have an enduring, it does mean that there is an enduring relationship, and there are obligations, not just before you begin working with Indigenous peoples, but during the process, and then also afterwards, those obligations remain in place, and it's important for people to be aware of that. So in the beginning, it's really important for you to do your research. You need to understand Indigenous peoples and their connections to not only the land and place that they come from, their connections to their language, connections to their images, connections to their cultural heritage, and also understand that they have this different worldview. So when I introduced myself, I spoke to my Māori heritage. I talked about my mountain, my maunga, ko Taranaki is my maunga, my mountain, my river, which is, my river, which is Tangohui, my canoe, which brought my people from the Pacific to New Zealand, which is the Aotea waka, Aotea canoe, sorry. And then I talked about my my tribal affiliation. So Ngāti Ruanui is my iwi, my tribe, and my sub-tribes are Hāmoa and Hāpōtiki. And the place where my people resided was Taiporohe Nui. That's my marae or my pā. So, so those connections, every time an Indigenous person will introduce themselves, they will refer to those connections to land and place. It happens almost every single time. And so being aware of how important those connections are. So when you're engaging with Indigenous peoples about genetic resources from their land and from their place, then understanding that they have this, close connection to those, not only the land and the place, but the genetic resources that lie there. And so that is inherent in everything that they do, and that's something that you need to be aware of when engaging. The same comments apply to language, and we've had examples of where people have misused and misappropriated aspects of different languages and used them inappropriately. And in New Zealand, for example, the Te Reo Māori, or the Māori language, is actually recognised as a taonga, a treasure. And so therefore, to be recognised as a treasure, it places it significantly high in our, it's another thing we value quite dearly. And so therefore, when you use our aspects of our language in a manner that is inappropriate, then that actually affects us quite significantly. And, we have examples of that causing offence. People say culturally inappropriate, but it actually is actually felt quite deeply. And so therefore, connections to language are important as well. Connections to images, so images of our mountains, our rivers, our marae, which is our sort of our homesteads, images of those places, images of our ancestors are also absolutely critical. Recently we've seen images of Māori women who have, the moko kaua, or the tattoo on their chins, and they've been misappropriated and, shown with their being bare-breasted. Those people are ancestors of some people that are still living today, and they have strong connections, and they know their connections to their ancestors, even though they are, 3 or 4 generations back. And those images that were originally taken, the copyright has expired. But those genealogical connections to those people are still strong, and so therefore to misuse those images in that way is culturally inappropriate, but also offensive at a number of levels. And so therefore, connections to our cultural heritage, connections to our songs, our dances, our histories, our legends as they're described, but we call them our pūrākau, our paki waitara. So even our, the legends that our pūrākau are the ones that we consider are true and staunch, and then our paki waitara are sort of the ones that are not necessarily true, but they have a lot of information that has been built up over many generations. They are also so important and held dear by traditional communities and Indigenous peoples around the world. And then lastly, this different worldview, and I do want to touch on this because and I'll use the example of Māori because that's what I know most about. We have a story that says that our gods, our god Tāne Mahuta, he created man and woman. He also created the birds, the trees and the birds that live within those trees. And so we believe we have a whakapapa connection. And what I mean there is a genealogical connection to the trees and birds. So we actually believe that we are related. And so therefore, as we are related, it is important upon us, it is imposed upon us, I should say, this responsibility to look after our trees, our birds, because they are our relations. And so I know that's quite an unusual concept to consider, but it places in context how Indigenous peoples view the world, why they have the strong connection to land, place, and what lies within it, and also why there is this deep feeling of hurt and offensiveness when those things are misused and misappropriated. So in the beginning, as I mentioned, research, so understanding those aspects is critical, and also educating yourself on those cultural practices that apply in those areas are also critical. And that's something that people engaging with Indigenous peoples do have to do on their own. You know, we will certainly help and guide, but you know, there has to be a willingness to actually do their own research, do that education piece in your own space. Respecting those is critical as well, because acknowledging, you know, that worldview, acknowledging that there is a different worldview, showing respect to it is actually something that is quite an easy thing for someone to do, and anyone engaging with an Indigenous group to do. It is about acknowledging that there is a different view and embracing that diversity at the same time. Excuse me. Acknowledging absolute sovereignty, and this is something that it was great to see the legislation in South America, which does grant this level of absolute sovereignty to the traditional communities. You know, in New Zealand, and this is a statement that has come through in the past, is that Māori want to be in control of things Māori. So, you know, absolute sovereignty over their cultural heritage is critical, and acknowledging that there is this feeling of needing to have this control as an important step, especially when engaging with Indigenous peoples. Consent before use is critical in the Convention on Biological Diversity. They call it prior informed consent. That stage is absolutely critical. Getting retrospective consent is generally going to be, what's the word I can use? Probably refused is probably good enough, but you're more unlikely to get a no if you go retrospectively. But one of the things with prior informed consent is that there is an obligation to actually make sure that the other side has the capacity and the capability to provide consent. So that means being upfront about what the agreed terms are, being upfront about what you intend to do with this aspect of cultural heritage, how long for, you know, and being very specific about sharing all of that information and why you wish to use this aspect of cultural heritage. And educate yourself, educate. Also, you know, there's an obligation on you to educate, perhaps in terms of helping to build up that capability and capacity within the Indigenous peoples themselves in this space. So in the middle, what things to, and some of the other speakers have touched on these points as well. So you've managed to reach an agreement with the Indigenous people around, you've got consent and you are able to use this aspect of cultural heritage, but in most cases what you will have created is a partnership. And so therefore, as I mentioned at the start, there is this ongoing obligation that will be imposed on you moving forward. So again, respect will be critical moving forward. So respect for the absolute sovereignty of the Indigenous peoples. That means that if you decide to change what you are doing, change your use of your mark or your image or use the genetic resources for a different reason, then you need to go back and get consent again and get consent related to that new use. You may have to re-educate again. You may need to again build up the capacity and capability within that relationship to ensure that they understand what they are consenting to. So respect is an ongoing obligation on the partner. Attribution and acknowledgement will be critical throughout the relationship. This will be something that will probably be negotiated as part of the agreed terms, but being prepared to actually acknowledge the contribution from the Indigenous community will be that will be something that should be an absolute minimum that is provided as part of these negotiations. There will be ongoing obligations on you to ensure that connections are maintained, and I mean ensure connections to land, to place, to the genetic resources, to the image that you may be using, to the words that you may be using. So maintaining that connection, and I know it's difficult to think about what that might look like, but perhaps I can use the example of the Haka Kamatea Attribution Act that we have here in New Zealand. The haka, which is a war dance, it's called kamatea. It's performed by almost at almost every event. It's usually used to celebrate or acknowledge some achievement. It's performed by our national rugby team before they start their game. It's performed by other teams as well before they compete in any sporting venture. So that haka was written by one of our leaders, our chiefs, Te Raupraha. The Act states that if anybody uses the haka, that haka in a commercial sense, then they must acknowledge that the haka was written by Te Raupraha, and they must acknowledge that he comes from a tribe called Ngāti Toa Rangatira. So, an acknowledgement like that, whilst it's, sort of relates to the attribution point I was making before, but, if it's a genetic resource, then an acknowledgement along those sorts of lines would be something that would be reasonable to include throughout your negotiations, throughout your relationship with the Indigenous people. The other point I have here is an obligation to ensure cultural practices maintained. So, I mentioned at the start that there are cultural practices that are involved with our genetic resources, for example, and I gave the example at the start of me into how I introduce myself. We refer to our mountains, our rivers, our canoes, and our place. So ensuring that those sort of practices are maintained. So ensuring that for Māori, ensuring that there is when you start a relationship, there is a karakia at the beginning. If you have a meeting, there's a karakia at the beginning, there's a karakia at the end. And then usually you would have so a karakia is a prayer, sorry, I'm using these terms with forgetting that most of you probably don't understand these terms. So apologies for that. And then afterwards we would have sit down and have a meal together, and that would be a normal meeting that we would have. I would have those sort of meetings every day. So cultural practices are critical throughout the relationship. So when you first engage, you will need to go through a process to be introduced to the community and and you will need to be led by their practices. As the relationship continues, those practices will need to be maintained throughout, and you will need to ensure that they are maintained throughout so that your relationship with the Indigenous community is maintained as well. I talked about any new going on consents required. And lastly, the ongoing relationship, I think, will also be is critical. So in the beginning, you will negotiate your prior and informed consent. There may also be an obligation on you to provide some benefits that flow back to the communities. And one of the other speakers talked about benefits flowing back as well. You know, those benefits can be monetary benefits, so they can be a license fee, they can be sort of a one-off charge, or any sort of payment, or they could be some sort of impose some sort of obligations on you to maintain a relationship with the community, help build up education, help build up food security if it's around genetic resources. All sorts of different kind of benefits could be imposed upon you as part of this relationship and this partnership moving forward. So it's important to ensure that you do meet those obligations that are imposed on you. And then in the end, the partnership may end, but for Indigenous peoples, once a partnership is signed up, then that partnership, it endures. And in fact, there probably is no end to that partnership. And so the obligations that have been agreed to will be imposed on both parties, forever. And you can refer back to that, forever and ever. In New Zealand, for example, the Treaty of Waitangi is considered one of the founding documents of New Zealand. And this treaty imposed obligations on Māori, but it also imposed obligations on the Crown. And, that was signed 180 years ago. And we still have a number of contentions, litigation as well, around what that relationship and what that means in terms of the obligations on each party. So it's important to recognize that, that treaty was signed over 180 years ago. These obligations are enduring. So obligations of respect remain in place. If there are obligations on you to cease use, so you've got consent to have access to genetic resources for 2 years, then you must stop use after stop access after 2 years. If there are obligations around use of any other materials, then you need to stop. And that's critical, especially if there's ever any possibility that you may wish to go back to that community to get consent again for another project. Return any materials that you must return that are not any cultural heritage materials. They are not yours for safekeeping. And an example I'll give here is I'm currently working with an iwi who had an exhibition at a museum here in New Zealand, and they are now looking at how they can take back all those materials that were housed at that museum for that period, so returning those materials. So there are obligations on you to return things in certain circumstances. As mentioned in the previous slide, ensure those connections are maintained forever. For Indigenous peoples, their obligations, their responsibilities in relation to those genetic resources, in relation to the traditional cultural expressions, they endure forever. And so those connections have to be maintained forever. Cultural practices around those the genetic resources, the traditional cultural expressions, and the traditional knowledge, again, must be maintained forever. And there will be some obligations that outlast even the ending of a relationship. And so you need to be, and as I mentioned right at the start, it's a partnership for Indigenous peoples. And so therefore it is something that has ongoing obligations on both sides. So that's my tips. I hope they're helpful, and I'll stop sharing my slides now. And I'll hand back to Karen. So ngā mihi nui ki a koutou katoa.
Thank you so much, Linnell. That was really so insightful, and sharing those practical guidelines to help us navigate a path to avoid the inadvertent mistakes that we all make and the errors of ignorance, and that checklist was really helpful. And I mean, really, I think it is really about mastering the art of appreciation to avoid that appropriation. So thank you very much for that. Okay, so now I would like to wrap up our session, but before we do, we've got a couple of questions which I will address shortly. But I just wanted to ask the panel of speakers, based on the different areas that each of you have presented today, what is a key tip and takeaway for us in the industry? I think most of the participants are either involved in intellectual property, they're either lawyers, they could be academics, they could be people in government, and I'm looking at the coverage of the audience today being either AIPPI members or friends of AIPPI who are online today. So can you just tell us what is the tip and takeaway, bearing in mind that we are in an environment where there is an intellectual property framework? Is there anything that we need to be mindful there in terms of protection for these communities, or the key tip and takeaway to make sure that we don't fall into the trap of because it is a really fine line between appreciation and the illustration, and that is sort of exhibiting the creativeness, and then falling foul into the trap of it being deemed to be appropriation. So maybe I can start off, do it the other way around. Linnell, maybe you go first, and then we work backwards with Audrey, Lydia, and finally Lily.
Yeah, I mean, I think Lydia probably touched on this actually, but I think research is absolutely critical in finding out, where the origins of things come from, and to avoid, this issue of appropriation. But for me, one of the key points is when engage, once you have identified the group, it really is about this partnership. And it's a mutual beneficial partnership that you'll be looking for, and to encourage you to think about what that actually means, so that there's mutual benefits flowing both ways.
Excellent, thanks. Audrey?
Yeah, thank you, Karen. I think it is important to recognize that providing appropriate legal protection for traditional cultural expressions requires a sui generis approach, so that the obstacles that traditional forms of IP right have posed are overcome. As we have seen, the traditional cultural expressions have their particularities that don't quite fit with the traditional forms of IP rights. So I think it is important to recognize that they actually require a special approach.
Thank you, Audrey. And Lydia.
Thanks, Karen. So, as Linnell said, I think research is very critical. I think when clients are looking to us, they're looking to us for our legal opinions, but I think it's also, we want to give business-minded approaches. So I think it's really important to see things both from a legal perspective, but also a public relations standpoint. So I think brands should be mindful, especially in this new found awareness of the importance of diversity and not misappropriating things.
Okay, great. And Lily?
Well, I think I would say that you should try to build a comprehensive strategy, which includes intellectual property and also measures for safeguarding cultural heritage, and also the respect of human rights. We haven't talked much about this, but there's an intersection between the protection of traditional cultural expressions and the respect of human rights, especially the UN Declaration on the Right of Indigenous People, which was adopted in 2007. So you have to keep this in mind, that exploiting some cultural heritage or traditional cultural expressions may be a violation of human rights. So that's very important. And on the point of combining IP and intangible cultural heritage, there are very interesting examples. I can cite one from France with the recognition of know-hows to make perfumes. And they have now registered a geographical indication to protect perfume extract. So they're doing this very global approach to their traditional cultural expressions.
Thank you, Lily. That's interesting. Okay, so now we go to the question and answers part of it before we wrap up. And there are a couple of questions here. So I'm going to read out the questions and throw it to the panel. Let me start off with the question from Nicholas Foote. What would the speakers regard as the most critical thing to ensure a robust IP protection of TK-TCE in the digital era, avoiding the pitfalls of cultural appropriation? Who would like to answer that? Audrey, did you want to start, since Panama has been very aggressive about having a legal framework? How do you see there being any difference in the digital era, whether there are peculiarities there in terms of enforcement and protection?
Yeah, well, since I believe that would be covered, because since our law forbids any unauthorized reproduction in any media. So if it's anything on the internet or I mean, any electronic or digital would be covered by our law, because it refers to any use, any unauthorized use in any media. So I believe that if such kind of conduct is has to be dealt with, the law would allow protection in that field also.
Okay. Linnell, is there anything in New Zealand that covers this specifically, or do you see any difference, whether or not it's, you know, in terms of appropriation sort of in brick and mortar as opposed to in cyberspace or in the digital era?
I mean, I agree with Audrey. I think if the you know, if we have a sui generis framework that actually protects TK and TCE as anticipated by, you know, as we need to, then that should be able to cover use in the digital era as well. I mean, we constantly, at the moment, we currently see, you know, misuse of, you know, people copy image, artists put their art on Facebook. An Australian company will, I shouldn't say Australian, an overseas company will borrow that image and then use it on a blanket and try and sell it. And, you know, that just happens all the time, but the laws just don't allow us to. I mean, if it's a contemporary piece, then they can use the copyright law to take action, but the cost of that is just prohibitive for a struggling artist. So the laws do need to be reformed, not just from to protect TK and TCEs, but there also needs to be some aspect of this, the process in terms of the cost of the process that also need to be addressed for Indigenous communities who don't have the money to engage with lawyers as well.
Great, thank you. Okay, I'm going to move to the next question. From Leon Rivera Aquino, thank you for your question. Domestic law as a sui generis IP protection system would protect TCEs and TK internally. However, this protection will not provide them protection in foreign countries. So the creation of an international instrument is the solution to avoid cultural appropriation. Maybe I can throw this to Lily, because you have talked about frameworks, international frameworks that have been put in place. And we're talking about the enforceability. So you have a situation like Panama where they have legal infrastructure, but how do you enforce someone else in another jurisdiction reproducing it? What are the, so I mean, I think that's basically the question that has been posed by Leon.
The premise is right. You won't be able to enforce it abroad because of the principle of territoriality. But what's interesting is that we see that some trade agreements have included articles protecting traditional knowledge and traditional cultural expressions. So you should also look at trade agreements, and you can find these type of articles also in some regional trade agreements. So this is a way to protect traditional knowledge and traditional cultural expressions while waiting until WIPO's instrument gets adopted. There's also some regional instruments that exist. So there's a protocol, and I'm not going to pronounce it right. It's the Swakompumun, and it's a RIPO, I think, that adopted it. So you have several states that have protection put into place in Africa. So you have some regional protection. So these are the sources you can look at when trying to enforce abroad rights on traditional cultural expressions or traditional knowledge.
Okay, thank you. There is a specific question for Audrey and Linnell from Danya Asokan. And the question is, what is your advice when you've obtained consent from one cultural community or tribe, and then another tribe or community shares a similar expression and are demanding acknowledgement and or compensation?
Yeah, well, I think first, whoever is interested in using traditional cultural expression has to do the research and find out and identify the indigenous community that owns the traditional cultural expression. And one way to do that would be also by visiting or consulting with the office in charge of either the Secretary of Culture or the Trademark Office, the authority that in the country is in charge of protecting traditional cultural expressions, because they have identified the different indigenous community in a country. And I think one of the approaches of the law, and for instance, in Mexico, that's the same thing. If you have any doubts as to how the identity of the indigenous community from which you need consent, you make a consultation. And the important thing is that the communities are specifically identified. I wouldn't see that problem arising here in Panama, because we have the groups are very well identified. So it wouldn't be something happening here in Panama, but I don't know, probably Linnell can add more on that.
Thanks, Audrey. I mean, we come across this issue quite often in New Zealand. We have you know, a number of overlapping genetic resources that grow across a number of areas. So therefore, you know, you do need to consult with the different tribes that have, you know, that are based in those areas. And so it is it does mean it is a convoluted process. You have to get consent from each of those communities. And whilst that does add time and effort, but it is the right thing to do, and it is something that is required.
Okay. Lydia, there's a question here which is on the cases that you've shown and you've shared with us today, the examples of where the cultural communities have protested or sued for appropriation of the cultures in the US. Where do they derive their legal standing in initiating those disputes? What is the legal sort of framework that supports proceeding?
Thanks, Karen. So I guess on one hand, there are trademark rights, which they've sued under. And then in the United States, you have the Indian Arts and Crafts Act, which prohibits misrepresentation in the marketing of Indian arts and craft products within the United States. So, all products have to be marked truthfully. If it comes from, if you have, for example, a turquoise squash blossom necklace, you can't call it an Indian jewelry if it's not made from a member of that particular community.
Okay. Well, thank you all very much. I think we need to wrap up. We've gone past our time. Thanks, everyone. It's been wonderful to have you, amazing ladies, share this topic with us today. And we hope that you'll be able to join us again in future as we take the subject too, because I think there's a lot of unresolved issues and whether or not we need to have a legal system and a sui generis system. Do we need to do that? Are IP laws sufficient or are they inadequate? And also whether we need to have an international treaty. I think that was one of the issues that was raised, and I think that's something that's very important for us to consider moving forward. Before wrapping up, I do want to tell everyone that there is the AIPPI World Congress that's going online on the 15th of October. And I'd like to urge you all to take the opportunity to sign up, take advantage of the early bird, which ends on the 24th of August. There are lots of opportunities to learn new subjects, a lot of cafe networking events and social events as well. So don't miss out on the opportunity to meet new people, to learn new things, and to be a part of this amazing organization. Thank you all, and have a great day for those of you who are still starting your day, and for the rest of us here, good night. Thank you.
Thank you. Good night.